The Supreme Court just received 9 new Second Amendment petitions on April 27, 2026, that could fundamentally reshape who can own guns and where you can possess them on your own property. By the end of this video, you will know the implications and details of these cases and what you should do. So let's get into it.
8 of these cases challenged the lifelong disarmament of people convicted of crimes, including nonviolent offenses, asking whether federal laws banning felons and indicted persons from firearms violate the Constitution under the Bruen framework. The 9th case challenges Maryland's default ban on firearms on private property unless owners explicitly post permission signs. If the court takes even half of these cases, gun rights in America will change dramatically in the next 18 months. Hit that subscribe button right now because these 9 petitions represent the next wave of Second Amendment litigation post-Bruen, and if you've ever been convicted of any crime, been indicted for anything, or own property where gun possession rules matter, what I'm about to reveal affects you directly. Here's what just happened. On April 27, 2026, the Supreme Court's docket received 9 new cert petitions, formal requests asking the court to review lower court decisions. 8 challenge 18 U.S.C., paragraph 922G1, and 18 U.S.C., paragraph 922, the federal laws that permanently ban convicted felons and indicted persons from possessing firearms. The petitioners argue these lifetime bans violate the Second Amendment under the historical tradition test established in New York State Rifle and Pistol Association versus Bruen. The 9th petition challenges a 4th Circuit decision upholding Maryland's law that presumes all private property owners ban firearms unless they post signs explicitly allowing them. Let me break down what these 8 felon disarmament cases argue, why Bruen makes them viable, what the Maryland private property case means for gun owners, how the court's indecision on assault weapon and magazine bans factors in, when we can expect decisions, and what you should do now. Number 1, the 8 felon disarmament cases, challenging lifetime gun bans for all crimes, including nonviolent offenses. The federal statutes, 18 U.S.C., paragraph 922G, or 1, prohibits any person convicted in any court of a crime punishable by imprisonment exceeding 1 year from possessing firearms. 18 U.S.C., paragraph 922 NN, prohibits indicted persons from receiving firearms. Together, these disarm convicted felons and indicted persons for life. The scope? Crime punishable by imprisonment exceeding 1 year includes many nonviolent offenses: tax evasion, mail fraud, drug possession, securities violations, regulatory crimes. If maximum sentence exceeds 1 year, conviction triggers lifetime firearm ban regardless of actual sentence, time passed, or violence. The constitutional challenge? Under Bruen's historical tradition framework, petitioners argue founding era and Reconstruction era laws didn't permanently disarm all felons for all crimes. Historical laws targeted dangerous or violent persons, not every felony level offense. Lifetime categorical bans lack historical analog. Why 8 petitions? Different circuits reached different post-Bruen conclusions on felon disarmament. Some upheld 922G1 entirely. Some struck down as applied to nonviolent offenders. Some created carve-outs. 8 petitioners from different circuits asked Supreme Court to resolve this split. If you're finding this helpful, imagine what you'll learn in my next video where I reveal which states are already preparing for the possibility that felon firearm bans get struck down and what gun control advocates are planning to do in response. Subscribe so you don't miss it. Number 2, why Bruen makes these felon disarmament challenges viable. Bruen fundamentally changed Second Amendment analysis. Pre-Bruen, courts used means-end scrutiny, balancing rights against government interests. Felon disarmament easy to uphold. Public safety outweighs felons' rights. Bruen's revolution, Supreme Court rejected balancing. Justice Thomas, the Constitution takes certain policy choices off the table. This is not a regulatory free-for-all. Courts must now examine historical tradition. Did founding or Reconstruction era have analogous restrictions? Historical problem: founding era didn't have felons as permanent legal class. Felonies were capital crimes. Execution eliminated disarmament question. For non-capital crimes, rights restored after sentence. Permanent civil disability for all felonies is modern, not historical. Reconstruction had some disarmament for rebellion participants in violent crimes, not all felonies. Petitioner's argument: government must show historical tradition of disarming similar persons for similar reasons. For violent crimes with force, maybe analogs exist. For nonviolent regulatory offenses, no historical tradition supports lifetime disarmament. Circuit split: 3rd Circuit upheld 922G1 for all felonies. 5th Circuit struck down as applied to nonviolent. 9th Circuit created case-by-case analysis. Split makes the Supreme Court review more likely. Quick legal note: this is educational information about pending Supreme Court petitions. This is not legal advice. If you've been convicted of crimes or face indictment, consult qualified attorneys about your specific situation. Gun laws are complex and consequences severe. Number 3, the Maryland private property gun ban case, Fourth Circuit decision, presuming all property bans firearms unless owners post otherwise. Maryland's law. Maryland creates default rule that all private property owners prohibit firearms unless they post conspicuous signs explicitly allowing them. Stores, restaurants, apartments, offices all presume gun bans unless owners affirmatively authorize. Fourth Circuit's reasoning, court upheld using Bruen's historical framework. Founding-era common law gave property owners broad rights to exclude people and prohibit weapons. Maryland's default respects property rights by allowing permission through signage, just flips presumption. Cert petitions argument, Fourth Circuit got history wrong. Founding-era property rights didn't include default government-imposed bans. Property owners could exclude persons, but government didn't presume bans. Maryland uses property law to restrict Second Amendment rights. Default should be constitutional rights apply unless owners restrict, not rights. Don't apply unless owners grant permission. National impact. If upheld, other states will copy. Every state could default to no guns on private property unless posted permission. De facto carry bans in most commercial spaces, even in constitutional carry states. Practical effect? Carry into store without posted permission, murder or crime, even if owner doesn't care. Owner never banned guns, state presumed ban for them. Hey, 73% of people watching right now aren't subscribed. Join the 50,000 gun owners getting these Supreme Court updates first. Subscribe, because when the court decides these cases, you need to know immediately how your gun rights changed. Number 4, why court's indecision on Duncan and Viramont's matters. The shadow docket revealing judicial priorities. Duncan vs. Bonta. California Magazine capacity limit, 10 rounds, challenge. Ninth Circuit upheld post Bruen. Cert petition filed. Court holding without action for months. No grant, no denial, silence. Viramonte vs. Bonta. California assault weapon ban challenge. Similar pattern. Ninth Circuit upheld, petition filed, court silent. What silence means? Either 1, justices divided, can't get 5 votes for these cases, or 2, waiting for better vehicles, cleaner records, clearer constitutional questions. Delay frustrates gun rights advocates expecting quick post-Bruen invalidation. How this affects 9 new petitions. Court might be more willing to take felon cases than assault weapon or magazine cases because felon cases present pure constitutional questions about who has Second Amendment rights, less politically charged, historical tradition analysis clearer for status-based prohibitions than weapon-type prohibitions. Alternatively, Maryland private property case presents property rights Second Amendment intersection that differs from weapons bans. Different questions might attract different coalitions. Number 5, realistic timeline for these 9 petitions. Cert process. Respondents file opposition briefs, 30 days. Petitioners file replies. Court conferences. Justices vote on which to grant. 4 justices needed to grant cert. Timeline. Petitions filed April 27, 2026. Opposition briefs due late May, early June. Replies mid-June. Court conferences June 2026, before summer, or October 2026, after return. If granted, oral arguments 2026-2027 term, Oct. 2026 to June 2027, decisions by June 2027. Grant probability, 8 felon cases have good chance, circuit split exists. When circuits disagree on constitutional questions, court usually steps in. Maryland case, lower probability. Only 1 circuit ruled, no split yet, but unusual constitutional questions might attract interest. If granted, expect government to argue public safety requires categorical bans. Petitioners argue historical tradition doesn't support lifetime disarmament for nonviolent crimes. Court could, 1, uphold 922 Tutsur G1 entirely, 2, strike down entirely, unlikely, or 3, create carve-out for nonviolent offenses, most likely. If denied, lower court decisions stand, circuit splits continue. Geographic lottery for gun rights. Number 6, what gun owners should do while petitions are pending. If convicted felon or under indictment, do not attempt to possess firearms while case is pending. Current law remains in effect. Violating 922 G1 or 922N carries up to 10 years federal prison. Wait for actual court decision. If gun rights advocate, support organizations funding litigation, SAF, FPC, GOA, cases cost millions through circuit courts and Supreme Court. Donate and join. If property owner in Maryland or Fourth Circuit, understand current law requires default gun bans unless posted permission. Post clear signage if you want firearms allowed. Monitor petition. For all gun owners, spread awareness. Most don't know 9 cert petitions filed. Most don't understand Bruen's implications for felon disarmament. Most don't know Maryland's private property presumption. Vote November 2026. Supreme Court deciding these cases exists because of judicial appointments. Future appointments depend on elections. Number 7. What these 9 petitions reveal about post-Bruen litigation. The pattern. Since Bruen, June 2022, hundreds of Second Amendment challenges filed in lower courts. Many lost at district and circuit levels. Strongest cases with circuit splits now reaching Supreme Court. These 9 petitions are second wave, testing how far Bruen extends beyond carry rights. Questions being tested: Bruen established commonly owned firearms for lawful purposes are protected. But questions remain. Who has Second Amendment rights? In felon cases? Where can rights be exercised? Maryland case. What restrictions survive historical tradition? All pending cases. The stakes. If court strikes categorical felon disarmament, potentially millions with nonviolent convictions could regain gun rights. If court strikes Maryland's private property presumption, carry rights expand significantly. If court continues delaying assault weapon and magazine cases, those bans might survive longer. Here's the bottom line. 9 Second Amendment cert petitions filed April 27, 2026. 8 challenge lifetime felon disarmament for all crimes including nonviolent offenses under 18 U.S.C. after 922(g) by Order 1 and 922N. 1 challenges Maryland's default gun ban on private property. Felon cases argue Bruen's historical tradition doesn't support permanent disarmament for nonviolent crimes. Circuit split makes Supreme Court review likely. Timeline. Court could grant by October 2026. Hear arguments 2026 to 2027 term, decide June 2027. Maryland case challenges Fourth Circuit ruling, presuming all private property bans guns unless owners post permission. If upheld, other states will copy. Court's indecision on Duncan and Viramonte's magazine assault weapon bans suggests justices might prioritize other questions first. Your action: don't violate current law, support litigation organizations, spread awareness, vote November 2026. These 9 test how far Bruen extends. Answers will reshape gun rights for decades. Subscribe right now because I'm tracking all 9 petitions and will break down every development from Supreme Court conferences through final decisions. Thanks for watching. Next video reveals which lower court gun cases are most likely to reach the Supreme Court next if the court rules favorably in these 9.